Hi, comrades. Today I am going to discuss with one of the active Comrade Gurusivam, Assistant Circuit Secretary, and also an eminent defense assistant. I am going to interact with him. Welcome, Guru.
Welcome, sir. Very happy, sir, to be here.
Very nice. Nice, Guru. What subject we can discuss today?
So, to begin with, a billion-dollar question, and so we can discuss about the deregulation.
Oh,
because
yes.
Many speculations has been floating in WhatsApp and other social media.
Yes.
So, please enlighten us. Why NFPE and AIPU Group C have been derecognized? It's been since 20 days. Department has derecognized the NFPE and AIPU Group C, and kindly intimate the progress in this regard and what action has been taken by CHU in overcoming this. Being an honorary member, everyone needs to know, sir.
You are absolutely correct. Actually, the government has initiated action in August 2022 itself. And finally, it gave show cause notice during March 2023, and finally they issued orders derecognizing the National Federation of Postal Employees and also the All India Postal Employees Union Group C. This is most unfortunate. We cannot wash dirty linens in public, and it is not our intention also. What is the reason why it was derecognized? Such things we need not discuss at this juncture. It can be discussed separately in the proper forum like All India Conference or Central Working Committee like this. Because being the Assistant Circuit Secretary of the Tamilnadu Circle Union, you are aware of these etiquette and also the protocols. Let us keep it reserved at this juncture. But one thing I can say, after the department derecognized our NFPE, we should have acted immediately, very quickly and very swiftly. That is the expectation of everyone. I do agree with you. Actually, many of our comrades, including the whole India, whole nation, many comrades don't know. Actually, during 2010, our All India Postal Employees Union Group C was derecognized by the Department of Post. How many of our comrades knows? I don't know. Actually, during 2010, on this slide, the Bharatiya Federation has filed a court case in Madras High Court. And immediately they got a favorable judgment for derecognition of All India Postal Employees Union Group C. Immediately, the department very swiftly acted and derecognized AIPU Group C on 19/4/2010. I was the General Secretary at that time. It was a very surprising and shocking, and we got the orders on 20th April. I attempted to get the copy of the affidavit and also the copy of the court case from the department, but I could not get it. On the very same day, I think it is 22nd April 2010, I requested Comrade Veeramani, who is a Circuit Secretary and also All India President of the All India Postal Employees Union Group C. He is expert in the court case. I can say very frankly, he is very expert in the court case. I requested him over phone from Delhi. Please try to get the copy of the court orders and also the affidavit if possible, because we have to contest and we have to protest this seriously. I requested him on 22nd. Anyhow, he got the copy of the orders and also valid documents from the court. And he sent all the documents through email to me on 24th April. That is within a matter of 4 days, everything is going very quickly. On 24th night, I sat whole night, prepared the affidavit, and also collected all the relevant documents. And also, at that time, I was in Delhi. So if I am putting the signature in the affidavit, it should be countersigned by one of the advocate practicing at Delhi High Court. It is also a compulsory at that time. And also the affidavit has to be taken print out in the green sheet only. So whole night I prepared, and next day morning I have gone to Delhi advocate and got my signature attested in the affidavit, and thereafter everything got ready only in the night. Night 12 o'clock, we have gone to the airport and booked the article through Indigo Airlines. So as it has to reach Chennai on the next day morning. So next day morning, it reached Chennai by 4:50 in the morning. Comrade Veeramani has went there, and he collected and handed over to the advocate, and immediately he filed the case within a week. I can tell you, within a week, we filed the case. And thereafter, they engaged, Bharatiya Union engaged a very eminent advocate and very famous advocate at that time. Our advocate, K.M. Ramesh, very expert and eminent person. He argued very effectively, and the court case, the court order was totally set aside within 10 days. Within 10 days, we moved an emergency petition, and within 10 days, it was passed. And thereafter, our department has given the recognition on 8th May 2020. You see the day, number of days between 19th to April to 5th May. Within matter of 20 days, we filed a court case, and it was argued. And at the time also, it was the vacation period, same period more or less. During the vacation period, we moved a special petition, and also we got it, and we quashed the orders, and thereafter, we got the recognition immediately on 8th May 2010. I am telling you an example. We should act very quickly and very swiftly. We should not delay things actually. If we are delaying things, it is not good for the moment. Actually, when recognition is freezed, what are all the options before us? We should fight organizationally. We should immediately announce an indefinite strike, and whatever be the consequences, we should have been face it. But we could not do it. Somehow it has not happened. The next and available remedy is the legal remedy. Legal remedy also, filing the case for protracting for 20 days or nowadays, it is too much time. Nowadays, it is possible to file any case within 24 hours or 48 hours. This one is very important. Number two, while filing a case, we should consider certain things, whether it is correct or wrong. Some amount has been transferred to the political party. Some political fund was there. It should not be accepted at the initial stage itself. It should not be accepted. Whatever be the charges, we should not accept immediately. Because you are also a Rule 14 expert. I am asking you a small question. Today, some charge sheet has come. The charge sheet, they are saying that you are misusing like this. Would you accept the same before going through the complaint? Before going through the complaint, would you accept it? First of all, you should get the complaint. First of all, you should get the complaint. What is there? And thereafter, you have to totally deny the allegations. Let it be a trial take place for 2 years, 3 years. By the time, we would have definitely managed certain things. But in this case, without calling for the report of the Bharatiya Union, I think the reply was prepared and sent, in which also they confessed as if the amount was sent. It is my fervent opinion, we should not give such a commitment. We should say, we never paid any amount to this. Let them prove it. What is the need of breaking our head? Actually, if anybody sought my advice, I would say like this only. Don't accept the charges. If you are accepting the charges, then you are giving handle to the concerned people. Actually, the disciplinary authority is taking advantage. Likewise, in this case also, it has been gone like this only, as per the information I am having. This much only I could say at this juncture. I cannot elaborate more also. And moreover, even tomorrow, if we are going to fight with the court of law, we should never accept that we have remitted the amount. We should say no amount was transferred. Suppose if you are saying, yes, that amount we have sent, what is the wrong in it? Definitely you will not get a stay or injunction order to the order. The case will continue for 2 years or even 3 years. By the time there will be a total turmoil, and under the existing circumstances and also the existing situation, it is very difficult to run the divisional unions and also the circle unions without recognition. Once we have climbed, without recognition, we will effectively function like this. But this is not the case as on today. It is very difficult to function without any recognition. So it is my fervent request to the leadership, please move the court immediately and don't accept. You can refute. There are more chances to refute. Whatever be the statement earlier you have given, you refute everything under some coercion, under some confidence, under something. We can say there are so many terms are there. Under the compression or duress, we have given the statement, but that is not correct. Likewise, you can definitely refute. And there are so many other points are also there. What is the provision for the submission of duplicate application for the membership? Suppose if the divisional secretary submitted a false membership declaration to the department, that fellow is not eligible to be a member till next verification. Exactly. As such, the person who is committing, he should alone be punished. But in this case, whether it happened, whether it reflects in the audited accounts of the All India Postal Employees Union Group C, nothing was seen. Simply accepted and immediately the union was sacked. Whoever be the person responsible, he should alone be responsible, and it is not the entire organization. The entire organization should not be derecognized. We are having plenty of points for filing a very effective case in the Delhi High Court. When you are filing a Delhi High Court, you should engage an eminent advocate, not an advocate belonging to any political party or any political affiliation, like Kapil Sibil or Abhishek Sangvi or so many things. Our CHU is having sufficient funds. We are having, it is not a problem. And also, if the major union is not in existence in one trade union sector, there is no question of survival of another union. So that also a very good valid point, and it is totally quashing the rights of the employees. There are so many points are there. These points should be taken note by the CHQ, and this should be seriously processed. This is my fervent request to the leadership.
In the event of deregulation of AIP Group C, whether the other unions having membership of 15% and 5% of membership can be functional, sir?
Actually, we cannot simply say that they should not be recognized, because the recognition process was done. During the recognition process, you got 35 and another union got 15. Okay. But you have been derecognized as an act of disciplinary action, for which you cannot demand that they should also be derecognized. Because your case is suspended. There is an animation is prevailing. Now at this juncture, an animation is prevailing because of your action. That does not mean that they should also be derecognized. The department will say like this only. Because we are now diverting our people also. Some of our comrades, some divisional secretaries are also asking me, why not we seek the minimum trade union facilities as if enjoyed to Bharatiya Union? Why should we demand? We are having the right to claim all the trade union facilities. That we have to fight, and we should not ask for the minimum trade union facilities as if given to the Bharatiya Union or any other union. That is not the correct stand. And secondly, because we have been derecognized, other unions should also be derecognized. That is also not correct stand. You should say that our derecognition itself is wrong. We have to come out from the situation. We should not divert our energy in saying you should derecognize other two unions. They are not having 35% like this. Because one thing you should not forget. The question of recognition comes at the time of membership verification. During the last membership verification, you got more than 35%, you are the first union. And the second union got it. Because as a part of disciplinary action, you have been derecognized. You have been, there is a suspension animation. But it cannot be taken as your rules to re-recognize the other federation. This is my opinion. This is my opinion. And government will not budge if we are demanding such, if you are placing such a demand. Anyhow, let us see. Already some demands were made on this line. Let us see what is going to happen.
Sir, whether there is any provision in our constitution to donate such funds to organizations such as CITU, Confederation of Government Employees, AITS, etc.
No, comrade. Actually, in the constitution, no such provision is there. Actually, the constitutional provisions we are interpreting to favor the present situation. But it is not the case as per the RSA rules. As per the RSA rules, there is no question of any fund transfer to any organization other than the interest of the postal employees.
Sir, it is implied in the derecognition order, it is implied that the alleged transaction has not been reflected in the audited account.
Yes.
Which has been present in the AAC.
Yes.
But some transaction had been made. So
yes.
There is some ambiguity, sir.
Actually, it was an allegation. It was not proved beyond doubt. The Bharatiya Federation has made some allegation. We should not say, yes, we have sent like this. No need for our confession. We should say, as per our audited account, no such amount was transferred to any political party. And also, from the beginning, I am very clear. If the court case is going together for NFPE and AIPU Group C, there will be some problem. We should file two cases separately. One for the All India Postal Employees Union Group C and another for the National Federation of Postal Employees. So for the All India Postal Employees Union Group C is concerned, there is only one transaction, the amount of 30,000 rupees transferred to farmers movement. That is also not directly transferred. It was transferred through the Confederation of Central Government Employees. It is very clearly reflected in the audited accounts of the AIPU Group C Union. So naturally, this amount was transferred to Confederation. We don't know how the amount was transferred to which, whether AIKS is the political farmers the party of the CPIM or we don't know. Amount was transferred to Confederation. The person who is responsible at the Confederation, he should be taken for task. Or the person who is holding the office in the NFPE, he should be taken for task. For which AIPU Group C cannot be held responsible since no such transaction was made as per the audited accounts of the chartered accounts. So this is a valid point for the court case and it should be moved separately. So far the NFPE is concerned, it should file a separate case. Barring this allegation, the amount was transferred to Confederation and there was no illegal transaction and the amount was not directly handed over to AIKS or something else. Likewise, the allegation against NFPE is only one thing only. That can be, that is amount, the transfer of amount to WFTU. When we are having a receipt to WFTU, WFTU is a foreign World Federation of Trade Unions in which we have remitted the amount. Even for example, our FNBO is still affiliated to UNI. They are putting in the letterpad also. UNI also. They are part of international trade unions. So we cannot simply say this amount is irregular. We can definitely come out. So separate case for NFPE and separate case for the P3, that should be filed. So both cases can be seriously pursued. We will definitely get some immediate relief for our organization. It is absolutely necessary that we should get an immediate stay for the order. Otherwise, it is very difficult for the branch level and circle level. And the delay so far filing the case, I am also not happy. I can say very frankly, even though I need not pass such comments, no need at all at this age and also at the retirement stage. And not retirement stage, I have already retired. And because I have served in the movement for more than 50 years, I cannot simply tolerate. And also many days sleepless nights because due to the derecognition of the National Federation of Postal Employees.
In many of the division, even P4, R3, R4 have been denied monthly meeting. Whether it is correct, sir?
No, it is wrong. I heard the department is going to issue a recent, a clarification very shortly on the subject. Actually, the derecognition was made only to P3 and also NFPE only. As per the RSA rules, if the recognition of a federation is withdrawn, the federated union should not call themselves affiliated to NFPE till the recognition was regained. I mean, whether till we are regaining our recognition, they should not have the affiliated to NFPE. That is the only condition. And rest, all the unions are having all the trade union rights, what they are enjoying today, and that should be considered to them 100%. There is no second opinion.
So you have said that there is a precedence of deregulation in the past. Even in I hear that in 1916, 1968, and now you are told that in 2010 also.
Yes.
What should be done by the state immediately? And even really this deregulation puts the employees of NFPE3 in despondency. There is no doubt in that. Also, there is an insurgency amidst the members. Why no serious agitation program has not been announced by CHU? So there is no second opening in that. So kindly update what should be done now by CHU and what's your advice, sir?
Many water has flown under the bridge. Now we need to discuss actually beating the bush will not yield any results. What I am saying, we should concentrate the court case, immediately file the case, get a stay order. Simultaneously, we should discuss with the minister. We should discuss with the Secretary Department of Post. If we are not meeting the Secretary or DG and simply avoiding to meeting them, it is also not correct. We should go them and nothing was happened. Some mistake happened. We will correct in the future. Please don't take it as a serious. Please grant recognition like this. We should discuss with the Secretary also, DG also, as well as we should meet the minister also and explain our clear position. If we are not doing any exercise, simply saying that we are filing means, naturally it will create problem only. But actually we don't like it. We want that it should be settled very smoothly, very effectively. And whatever be the suggestion or ideas, thought, I will definitely cooperate and do my best for the early restoration of recognition to our NFPE and P3 union. Thank you, Guru. We have discussed a lot about this. Comrades, I am telling one thing very frankly. Some of you would have think, what is the need of disclosing all these things in open? For the last 20 days, I am repeatedly saying inside the forum, but nothing was taken very serious. But this is a very serious situation. And to come out whatever be the little knowledge I am possessing, I know, I want to share with all our comrades, particularly the circuit secretaries and also the office bearers, so that they can effectively pursue and they can effectively discuss with the leadership so that we can emerge and also we can ensure the swift action to restore the recognition at the earliest. With this, I am concluding this episode. Let us meet in the next. Thank you, Guru. Thank you very much.
Thank you, sir.